Good afternoon, boys and girls, friends and lovers, children of all ages. You haven't seen my face in a while, probably. My name's Brian Loma, a.k.a. Cut the Plastic, and I'm here today to bring you a Colorado State legislative session. We are awaiting, oh, there it is right now, the Zoom link for the Colorado State Legislature. See, it turns out that they have an affordable housing program fund committee for the state, not just the city of Denver, but the whole state of Colorado. And I found out about this because Twitter's a great thing, but it notified me the day that the survey was closing. And nobody wants to miss out on a good survey, so I tried to get on it, and then it was gone. And then I learned that today they're having a legislative session. And if they're going to have a legislative session online, we all should attend. It's my opinion anyway. In the meantime, some of you may be asking, Brian, where have you been? I've been working hard, printing clothes like this. Monday, Mutual Aid Monday hoodie. You can find these from Mutual Aid Monday Nights, the program that feeds clothes and does whatever the fuck we can for the community members who need our help. That's Monday nights outside City Hall, 4 to 7:30. And we're just literally sitting here in the Zoom waiting for the meeting because the guy in the chat said, hey, we're going to do a new one in a different chat. And so I followed it immediately. And I might have to go back to the original one and say there's nobody here because it's 6:02. And we want that to happen. So I might just go back. StreamYard is sharing a window. Yep, that's fine. We want them to share that window. That's done. Here we go, folks. Enjoy.
Thank you. I can mute everyone. All right, so I have muted everyone. Thank you so much for joining us. Sorry about that technical difficulty, but I sent out a different link. So thank you all for finding your way this way. We're going to give it a few more minutes to let everyone else join as well, and then we'll get started really quick here. See your picture. For those who are just joining, we're just waiting a few more minutes for everyone else to make it over from the other Zoom link.
There we go. Now I'm unmuted. All right. So, Laura, are you there?
Yeah, MJ, we're going to wait just a few more minutes, and then I'll let you do the intro. But we're waiting for people to keep trickling in.
What's up, guys?
Hi, Dara. We have everyone here. Thank you, Andrea, for sending that link around. We'll give it just a minute or two more.
Hot.
I am muting everyone for now. Once we get started, feel free to come off mute when you have something to share. It's your time.
Sorry, folks. I didn't realize that I wasn't sharing
All right. Hey, Lauren,
the screen.
you said you were going to do the intro?
Nope. I'm leaving that to you, but it'll be in a minute or two. Is that okay?
Oh, no, that is perfectly okay with me. You just let me I just need to get my tablet out so it gives me send me a message or a cue for the part that I'm doing.
Will do.
Awesome, thank you.
All right. Jack, do you think we should go ahead and get started?
Yeah, let's do it.
Okay. Let me pull up the PowerPoint.
Hi everybody, my name is Andrea Saito and I'm here with the Community Language Cooperative to help us all create a space of language justice where we can speak and hear in the language of our heart. To do that, we're going to offer simultaneous interpretation in English and Spanish. And once we turn it on, or you might already be seeing it, you're going to see a world map at the bottom of your screen, or 3 dots, or what it says more if you're on a tablet or your phone. And you're going to be able to select your preferred language. If you're fully bilingual, you do not need to select one of those languages. Hola a todos, mi nombre es Andrea, estoy aquí con la Community Language Cooperative para ayudarnos a crear un espacio de justicia del lenguaje donde podamos hablar y escuchar en el idioma de nuestro corazón. Para esto vamos a utilizar la herramienta de la interpretación simultánea aquí en Zoom, en inglés y en español. Cuando aprendamos esta herramienta, tú vas a ver un mapamundo en la parte inferior de tu pantalla o 3 punticos donde dice More si estás en tu tableta o en tu teléfono. Por favor, selecciónalo y escoge el idioma de tu corazón. Si eres bilingüe, no debes seleccionar ninguno de los dos. Please make sure that after you select your language, you also do mute original so that you don't hear 2 languages at the same time. Here we go.
Thank you so much. All right, let me share my screen here. I am going to be recording this so you can watch it afterwards to refresh on what you learned today, or share it with other friends who may not be speaking aloud. Feel free to put your questions in the chat and we won't call out your name. One moment. Get that started. And I will pick it to.
Hey, folks, we're just going to say hi to Keith, DJ K. Dot, Happy Hippie, all around the pig. Pork. Carol Funk, Happy Hippie. Thanks for joining. Here we go. We're now live.
Thank you so much for joining us today.
How's it sound?
A little bit about Colorado Poverty Law Project. We strive to prevent homelessness
Goodbye.
through legal representation, education, and advocacy. And we believe that no one should become homeless for the lack of access to housing justice.
Ready.
We're a
Your phone is
nonprofit here in
connected.
Colorado, working with tenants to prevent any evictions or support them in other housing issues. I'm going to kick it to MJ now to talk a little bit about our young adult initiative.
All right, so all of our work is done in partnership with Young Adult Committed Advocates. Our mission is to empower young adults to understand the rights they have when renting a place to live and how to advocate for themselves. Please check us out on Facebook, Instagram, and TikTok even. Our handle is at YATA, that's YATA, Young Adult Tenant Advocate. 5280. Once again, that's going to be YATA 5280.
Recording in progress.
Thank you so much. And so we have MJ, Domo, and Shelby here today. They are incredible young adult tenant advocate volunteers. So I'll be asking questions throughout the presentation and open to answering any questions you might have for them as well. So on you, Jack.
Great, thank you. If we could move to the next slide. Well, first, good evening, everyone. My name is Jack Regenbogen, and I'm an attorney at the Colorado Poverty Law Project. We are a nonprofit organization that provides legal resources and representation to Coloradans who are experiencing housing-related issues. Thank you so much to the Young Adult Tenant Advocates for the incredible work that you do in our community. And thank you all for being here tonight. really appreciate your time, and I am so excited to discuss some of the major improvements in Colorado's landlord-tenant law that were passed over the last year. As many of us know, housing insecurity was already a major challenge in Colorado even before the pandemic. One national study ranked Colorado 43rd among all 50 states in terms of its renter protections. With the ongoing pandemic and the corresponding job loss that it's caused, many of Colorado's renters are facing incredibly challenging times. In light of these issues, the Colorado General Assembly recently passed several pieces of legislation that are intended to bolster housing security for tenants. And I would like to spend my presentation this evening discussing what exactly this legislation does and why it's so crucial for Colorado. Please note that what I'm about to present is just information. It's not legal advice. However, before I dive into this information, I wanted to stress one thing. And in fact, if there's one thing that you take away from this presentation, I hope it's this. If you are facing a tough housing problem, please know that you are not alone. There are people and organizations, an entire community that is here to offer help. If after this presentation you feel like you need to talk to someone about your housing situation, or you feel like you could benefit from having an advocate, please, please, please reach out to us at the Colorado Poverty Law Project. We are here to help, and we promise to do so free of charge, confidentially, and without any judgment. And we really appreciate you being here to tune in tonight. Next slide, please. The new law that I'd like to spend most of my time discussing this evening is Senate Bill 173, which is a bill that reformed the eviction court process and protects tenants from excessive rental late fees. This bill became effective on October 1st, so pretty recently, and it has a few different elements, but overall, it will help to instill greater fairness in housing in a couple of different ways. First, this law has established some reasonable safeguards around the charging of rental late fees. Late fees were already a major concern even before the pandemic, and the problems that late fees cause have become even more urgent post-COVID. These fees are meant to reimburse landlords for the actual cost that they incur when tracking down late payments. They are not meant to be a penalty, and they're not meant to be a source of revenue for landlords. Unfortunately, we have often seen excessive late fees, which have been a contributing factor in evictions. And in fact, some evictions have occurred solely on the basis of unpaid late fees. Now, Senate Bill 173 addressed these issues by establishing a new law, which has a 7-day grace period before renters may be charged a fee. This means that if rent is due on the 1st of the month, someone may be charged a late fee on the 8th of the month. Also, late fees will be capped at either $50 or 5% of the past due rent payment, whichever is greater. Importantly, renters will no longer face a possible eviction solely due to unpaid late fees, nor will they be charged any interest on late fee debts. Furthermore, late fees will have to be disclosed in a rental agreement or in a lease. And to charge a late fee, a landlord now will have to serve notice of that fee within 180 days after the rent was due. So in other words, a landlord can't charge a late fee for a late payment that is older than 6 months unless they've previously given notice of that fee. Please also note that a landlord will not be allowed to recoup a late fee from a future rental payment that's made. So those rent payments will have to be applied towards rent, which we hope will prevent a cycle of debt in which rental payments are considered incomplete and thus late and subject to a new fee. Finally, a tenant will not be charged a fee if they receive assistance from a subsidy provider, like a housing authority or a nonprofit, when that subsidy provider gives their portion of rent late. Next slide, please. It's important to note that these protections apply equally to mobile home park residents as well as other types of tenants. The only difference to be aware of is that mobile home park residents may be entitled to a 10-day grace period instead of a 7-day grace period before being charged a fee. Now, what options does someone have if they are improperly charged a late fee? The law now automatically allows for a $50 penalty for any initial violation. Beyond that, a renter must give their landlord written or electronic notice that the fee that was charged was improper, that it violated the new laws. And then the landlord has 7 days to fix their violation, which they might do by refunding the late fee. If a landlord doesn't correct their mistake, a renter may seek damages from their landlord, which include an additional penalty ranging from $150 to $1,000, as well as attorney fees, court costs, and other types of relief. It's also worth noting that if late fees are a reason why someone is facing an eviction, and these new protections have been violated, then a renter may raise those violations as a defense to the eviction, which is important and helpful. Collectively, these changes will protect renters from excessive and burdensome late fees. If you are concerned that your landlord may be improperly charging you late fees, for example, by charging a late fee but calling it something else, like an administrative fee, please reach out to us in case we may be able to offer help. Next slide, please. This new law, Senate Bill 173, will also bring some much needed reforms to Colorado's eviction court process. And please note that evictions are sometimes called FEDs, or forcible entry and detainer petitions. It's a mouthful. That's just another way of saying eviction. Now, these reforms include a right to pay any remaining rent until an eviction is actually ordered, a right to obtain documents from a landlord, having 7 days to prepare for a trial, potentially some new grace when filing a response to an eviction, more opportunities to assert a defense if someone has experienced unsafe or unhealthy living conditions, and several other protections that I will discuss in more detail momentarily. Next slide, please. So first, this new law allows renters to pay outstanding rent at any point until a court orders the eviction. Now, under the old law, a renter actually lost the legal right to pay back an unpaid rent debt after the period of their rent demand expired, which is typically 10 days. This means that once an eviction was filed, even if someone could come up with the full amount of any debt that was still owed, the landlord could refuse to accept it and continue with the eviction, which was outrageous. Now, this new law changed all of that by giving renters the right to pay at any point during the eviction process before the eviction is ordered. This will improve the effectiveness of emergency rental assistance programs, which we know can often take at least a few weeks to turn around applications. Now, a couple of points to keep in mind. First, in order to square away the eviction, a renter must pay the full amount that is demanded in the notice that they received, plus any rent that may have accrued while the case was pending. If a renter doesn't believe that they owe the full amount that was demanded, then they would want to explain that and why that's the case in the answer that they file with the court. Now, in order to pay back this rent, a tenant may pay either their landlord or the court, and they probably should keep a record of this, especially if they pay their landlord. Put it in writing, take a screenshot, keep a record of the emails, anything that someone can do to document that they've paid what they owe can be helpful if there's any disagreement about that. Once the court confirms that payment has been made, it should dismiss the eviction. Please note that this is such an important right that the legislature has said it cannot be waived in any lease agreement. This right exists until the court orders an eviction, which is sometimes known as a judgment for possession. As a practical matter, if someone knows that they may not be able to pay rent or pay rent on time, the sooner that they can take steps to address that, the better. So in Denver, people can call 311 and get connected with emergency rental assistance providers. And outside of Denver, other Coloradans can call 211 and also get connected with rental assistance. Folks can also reach out to us at the Colorado Poverty Law Project, and we can help connect people with housing navigation services. If someone expects to be late with rent, it can also sometimes be helpful for them to be proactive in communicating that with their landlord. Now, this new law is a step in the right direction because it allows renters to have additional time to pay back rent even after the eviction is filed. However, if there's a positive relationship with good communication between a renter and their landlord, it's often best to communicate what the issue is, to explain when rent will be paid, and to try to prevent the eviction from being filed in the first place. Next slide, please.
Yeah, I see MJ has her hand raised. Is there something that you wanted to ask about this material?
Yes, there is. My question is about the occurring rent while going through the eviction process. I wanted to make sure that I heard you correctly. Was that they can or no they cannot add that to the amount that's owed?
Thank you for that question. Let me give an example to help illustrate what I meant. Let's say that I am served with a rent demand in the middle of the month, saying I owe $1,000 in back rent, and the eviction is filed on the 25th. My rent is due on the 1st. In order to square away the eviction and settle the debt, I would have to pay the $1,000 that I owe according to the demand. And if I pay after the 1st, so now there's a whole nother month where rent is due, I would also possibly have to pay that additional rent that has accrued while the case was pending. So this won't necessarily matter, but it's important to keep in mind, especially if the eviction falls right around the time that rent becomes due, because it's possible that you will owe that new rent on top of what was previously demanded.
Okay, great, thank you. I just wanted to confirm that, because I know sometimes these notices get issued later in the month, and it does. And anytime I've ever received one, it has said that other charges can occur, other late fees and charges, but it doesn't say anything about additional rent. So I just wanted to make sure that was clarified.
That's a great point, and let me clarify the question about late fees and other types of debt. In order to satisfy the eviction, the rent demand, you have to pay what was owed. So that may include other types of fees. It may include court costs. But in terms of the additional amount, it's only rent that accrues. So again, let's say that I am $1,000 behind the rent, and I've also incurred a late fee of $50, which is the cap on many late fees now. So I owe $1,000 in back rent plus $50. I receive a letter that says you owe $1,050. I have to pay that plus any rent that becomes due the following month, but not necessarily any extra fees. The only other thing that has to be tacked on is the extra rent. It doesn't mean that I won't be charged another late fee in the future, but in order to settle this particular eviction, you're responsible for whatever is demanded and any rent, though not necessarily fees, that accrues while the case is pending. Also,
do I need to be served another notice for that additional rent amount, or is the amount on the notice what I should go off of?
My understanding is that you may not be served an additional notice, that in order to cure the debts or to settle eviction case, the court will look to see if you've paid the amount that was demanded plus any rent that is accrued while the case was pending. So I would not necessarily expect another notice, but I would expect an additional notice if the rent accrues after the eviction is filed, or if there are other types of fees that accrue after the case is filed.
Perfect. Thank you. That answers all my questions at the moment.
Great. All right, we're moving right along. This new law also guarantees that a renter has the right to request and obtain evidence from their landlord that is relevant to the eviction. For example, this should allow a renter to ask for a copy of their lease agreement, as well as rent receipts and records of money transfers, documentation of any alleged lease violations, as well as documentation of unsafe living conditions. So, for example, did the landlord actually contact pest control? Did they place an order to repair the problems that were in the housing? Did they agree to a reduction of rent or a postponement of rent? These are the types of documents that someone might want to ask for in response to an eviction. Anything that might be relevant to the eviction, a renter should now be able to request. And although I'm not sure if this has happened yet, there should also soon be a form that is included with any eviction summons that the court sends that will allow someone to request the documentation that they need in order to make their case before the court. Please note that it's possible that a landlord may also ask a renter to provide documentation that's relevant to the issue at hand, which is another reason why it may be helpful to keep a record of any correspondence with the landlord. This is a basic procedural right in most other types of legal disputes. And so I am personally very grateful to see that this right has now finally been extended to eviction cases. Next slide, please.
Sorry to interrupt again, Jack, but we have another question. Shelby?
I didn't have a question. I just wanted to reiterate to everybody that if you are ever hesitant on what proper documentation may be, how to get it, or who to contact on where to submit any of these papers in response to an eviction, to please reach out to Colorado Property Law Project, because they are more than happy to help you.
Awesome. Thank you. All right,
Thank
the
you.
next slide.
All right. Now, another one of the issues that this new law addressed is the timing for when a renter must respond to an eviction. When an eviction is filed, a renter will receive a summons, which is a letter from a court that asks the renter to respond to the eviction by filing what is called an answer, or a formal response to the eviction. Now, this summons will typically ask a renter to appear in court by a certain date and time to provide the answer in response to the eviction filing. If possible, and I cannot stress this enough, it's always best for someone to provide this answer by the time listed on the summons. Because if the answer is given late, then the court may order what is called a default judgment, which is basically an automatic eviction that is ordered because a renter failed to appear on time. Now, this new law was intended to help people by requiring that courts wait until the end of their business day before ordering these default judgments. Unfortunately, however, there may be some courts that are still inclined to issue these default evictions even before close of business, which is why it's always best to err on the side of caution and appear in court to file the answer by the date and time listed, if possible. Please, to Shelby's last point, please contact us at the Colorado Poverty Law Project if you have any questions about how to do this, because we can help explain the process and also offer guidance on how to file the answer to make sure that a default eviction does not occur. Next slide, please.
Hey, Jack, real quick, there's a question in the chat, and pienso que estar de las palabras de...
And I think that the words...
Yeah. Go ahead.
Oh, Shannon, if you're speaking in Spanish, you need to be in the Spanish channel.
Well, okay. How about you do this?
Oh, okay. Then you say it in English and I'll interpret in Spanish.
I just think that the question was, and you might be more correct than I am, could this new law help pave the way for a change in rent control in Colorado? And I think this question was previous about rent control. So that's all.
I appreciate that question. And of course, we don't know what the future may hold, but my answer is I hope so. As we collectively work together to advance new protections for tenants, one of the most pressing issues facing renters in Colorado is the unregulated increased cost of rent that can occur every year. And it's pricing many renters out of the neighborhoods where they live. And so my hope is that as the state moves in this direction of expanding procedural rights for renters, that they also look at that really big issue of rent and what can we do to help rein in the unaffordability of housing. There are groups such as 9 to 5 Colorado, United for a New Economy, and the Homes for All Coalition that have really made this a priority. And if you're interested in getting involved in some of the efforts to pursue rent control, please feel free to reach out to me and I can connect you with them, or feel free to reach out to them directly because they're doing some of the amazing work pushing for these new protections. I appreciate that question. All right. And also, everyone, please know that I do have time reserved at the end of this for other questions. I like being asked while they're on top of mind, so feel free to inject. That way you don't have to hear me talk for too long. But if you don't have the opportunity to ask your question before the end of this presentation, please know we will have some time allotted at the end. And with that, can we please move on to the next slide?
I have a question really quick while we are moving on to the next slide about filing fees when filing an answer to that eviction.
That's a great question. There are typically filing fees that are charged when someone is responding to an eviction, but these fees may be waived for people who can demonstrate that their income is below a certain amount. And so there's a form that's available on the state judicial website that really we hope will start to be included with every eviction summons, but it's not right now. So you have to go on the website to find it, where you can ask the court to waive that filing fee. And again, this is another step in the process that can trip many people up. And so if there's any uncertainty about how to do this, please do reach out to the Colorado Poverty Law Project or to another organization that provides legal assistance so that we can help ensure that those filing fees are waived if possible.
Okay, and then when filing those filing fees, do those days count against, or when filing that form with the court, to get those filing fees waived, does that count against your 7-day time frame to file an answer?
Fantastic question.
Well, the 7 days applies regardless of whether you are able to get the fee waived or not. So if you need more time to come up with the money for the filing fee, then that's not necessarily going to be a basis for the court to extend that 7-day time frame. But again, in many cases for people who are facing a possible eviction, those fees can and should be waived. And so we hope that that's not going to prove to be a barrier for people to be able to actively participate in their defense of the eviction.
Mm-hmm. I guess to be more specific about that question is if I don't file that request with the court until the 5th day, does that, does the court then extend that 7 days until they give me an answer?
The court will not. The court will probably respond to your answer and the filing fee request at the same time, is my understanding. It won't necessarily provide someone with more time if you ask for that filing fee to be waived, because a lot of times my understanding is that the answer that's submitted and the request to waive the filing fee are both considered right around the same time.
Okay. All right, thank you.
All right. Would you mind moving on to the next slide? Oh, perfect. All right. So this new law also provides renters with at least 7 days to prepare for a trial, whereas previously, a court may have held that trial on the very first date that a tenant is due to appear in court. This is crucially important for ensuring that tenants have adequate time to prepare for their case and or to obtain legal assistance. Of course, 7 days still isn't a ton of time, but it is certainly better than having just a couple of hours, which is what people used to have in many cases before a trial would be set. Now, please note that courts are also generally discouraged from setting trial more than 10 days out from the date that a renter must first appear in court. So we can generally expect that a trial would occur somewhere between 7 and 10 days. However, this can be extended if someone demonstrates good cause or if the court finds justification for an extension. Finally, please note that this does not apply when a substantial violation is alleged. That's a legal term, but it generally refers to very serious lease violations, like criminal or dangerous behavior. In these cases, a trial may be set sooner than 7 days. Next slide, please. Next, this new law also modified the requirements that in the past had forced renters to pay bond to the court when they wanted to raise a defense that their rent was incomplete because their home was unsafe and unhealthy to live in. Previously, if a tenant wanted to raise that defense, that they didn't pay rent because their place is unsafe or uninhabitable, they would have first had to pay the court an amount that equals their monthly rent. And in practice, this prevented many renters from being able to raise these very valid defenses. With the passage of this new law, this requirement may now be waived for tenants who have incomes below a certain amount. And specifically, in order to have this waived, tenants must have either incomes that are 5 times or less the cost of their annual rents, or it can be waived if their income is at or below 250% of the federal poverty line. Importantly, this calculation does not take into account a tenant's assets, so it doesn't matter what property they might own. For reference, I understand that 250% of the federal poverty line for a single person household is a little more than $32,000 annually. It's $43,550 for a 2-person household, $54,900 for a 3-person household, and $66,250 for a 4-person household. And these numbers are updated each year, and these income limits are also available online. And so if you are in a household that is either at or below those income amounts, what it means is you should be able to raise these habitability, health and safety defenses without having to pay an extra amount to the court first. So hopefully, this will mean that for many people, this bond will not be required, and that folks can raise these issues without having to pay the court any extra money. I should note, however, that this is not a complete defense to an eviction. So even if the court agrees, yeah, that wasn't safe, that wasn't healthy for you to live like that, a court may still require that a renter pay a portion of the rent after accounting for the cost of repairs and the reduction of the fair market value that was caused by those health and safety issues. Now, even with this change, it can still be very challenging for renters to assert a defense that their residence was unsafe or unhealthy. There's a lot of cumbersome steps in the process. And for those reasons, I strongly recommend that if someone finds themselves in that situation, please consider reaching out to us or to another organization that provides legal assistance so that we can talk through the situation and provide advice and help. Nonetheless, this new law is a very big improvement in terms of expanding access to justice for safe and healthy housing. Next slide, please. Additionally, this new law will ban what are called one-way fee shifting clauses in leases. These are clauses that require a renter to reimburse a landlord for court costs and attorney's fees, but not the other way around. So that's why it's one way, is that the renter would have to pay back the landlord, but the landlord wouldn't have to pay back the renter. These are unfair, and under this new law, they're not allowed. These clauses can often deprive renters from being able to obtain justice when rights are violated. Under this new law, any fee shifting, or anytime someone's trying to recoup a reimbursement from the other side, it must go both ways and award cost to whoever is the prevailing successful party. This is probably a good moment for me to pause and note that while these types of clauses are now illegal, leases often include sneaky provisions that are frankly unfair and that may cause unanticipated problems. So it is always helpful for renters to read over the terms of a lease very closely before signing. And if you have any questions, please do reach out to us again. And we are happy to help make sure that we can explain any provisions on the lease that may be confusing to understand. Next slide, please. Finally, this new law will also add additional damages and opportunities for relief when a renter is illegally evicted. Under Colorado law, it is generally illegal for a landlord to evict a renter without a court order by locking them out or changing the locks or by shutting off utilities so that you can't live there. In practice, however, this still happens with some regularity, in large part because when it has happened, there have never been appropriate remedies available to renters to address that type of situation. It can be really tough to quantify and put a dollar figure to the losses that a person experienced as a result of having been deprived access to their property. We know people who have lost very important family belongings, property that frankly is irreplaceable and priceless. And so what this bill did, what this new law does, is it establishes a minimum amount of damages that a renter is entitled to receive when they're illegally evicted or they're locked out. Either $5,000 or 3 times the cost of their rent, whichever is greater. Renters may also...
Jack, I'm sorry, can you repeat the amounts?
Oh, of course, thank you. The bill established a minimum amount of damages of either $5,000 or 3 times the cost of rent. So whatever someone is paying in rent, if they're paying $2,000 a month, it would be a $6,000 penalty because it's 3 times the cost of rent or $5,000, whichever is greater. Now, on top of that, renters may also recoup what are called compensatory damages for any additional specific losses that they've suffered from having been illegally evicted. And they may also recuperate court costs and attorney's fees. Finally, judges are now also empowered to restore possession to a renter who was illegally locked out. meaning that they might allow someone to move back into their home after having been illegally evicted. Now, our hope is that with these additional remedies, it will provide a meaningful deterrent for illegal evictions so that they won't happen to begin with. However, if it does happen, please do consider reaching out to us for assistance. These are very serious violations, and we are here to help. All right, so this recaps all of the main changes in Senate Bill 173. There are still many more improvements to the eviction process that are needed to ensure that it operates fairly. That said, my hope is that with these changes, it will ensure that the eviction process provides renters with the appropriate rights, allowing them to defend and maintain their housing. Next slide, please. On a related topic, another bill that passed this year that I wanted to mention is House Bill 1121, which modified time frames in the eviction process. Specifically, this bill provides additional time to move after an eviction, giving people at least 10 days, which is increased from what was only 2 days, which hopefully will help many people avoid having to move into a shelter, and will also help provide time for people to find storage so that they don't risk losing all of their property. And 10 days still is not a ton of time, but it's an improvement over 2 days. And please note that these 10 days are measured from the date that the court orders that judgment for possession. That's what starts the 10-day clock. This law also created some new protections around rent, and specifically, it limits rental increases to once per 12 months. So from now on, landlords can only raise rent once within a 12-month period. Additionally, for renters who don't have a written lease, who are month to month, it also requires 60-day notice before rent may be increased. These changes are intended to help ensure that people have time to budget and to save for an increase in the cost of their housing. Next slide, please. Finally, I wanted to mention one other law that passed, House Bill 1054, which eliminated what are called lawful residency requirements for housing assistance. In other words, any housing assistance that the state offers, whether it be a voucher program, emergency rental assistance, or something else, will be available to anyone who needs it, regardless of whether they have documentation to demonstrate their immigration status. The only restriction that I unfortunately have to mention is that this does not necessarily apply to federal, national programs that have their own restrictions. Nonetheless, my hope is that this will help ensure that everyone is able to access the assistance that they need, regardless of immigration status. Next slide, please. In our remaining time, before we get to any other questions you might have, I wanted to mention some of the other important protections for renters. And one of the most significant, which was passed in the last few years, is Colorado's Rental Application Fairness Act, which established new standards for what a landlord may charge as part of a rental application. In particular, rental application fees must be limited to the actual out-of-pocket costs incurred by a landlord or the average expense per applicant. They can't just pick a number and charge it and obtain as much revenue from these rental application fees as possible. It has to actually reflect what their costs are when they're screening a rental applicant. Application fees also have to be consistent for all units that are offered by a landlord. They have to be the same. And if a landlord uses a third-party company, some other company, to evaluate their rental applicants, then the landlord must give a copy of that company's report so that the applicant knows what information is being considered. A landlord must also give notice to a rental applicant of their denial within 20 calendar days after making the decision. So in other words, landlords are not allowed to ghost applicants and never respond. They need to give a notice within 20 days after making a decision. Additionally, landlords must provide an itemized list of their anticipated expenses, or more commonly, a receipt for the cost that they incur when they charge a rental application fee. Landlords may provide a digital receipt, but if asked, they have to provide a paper copy if you need one. Finally, if any amount of a rental application fee is not used, the remaining amount should be returned and refunded to the applicant within 20 calendar days. Next slide, please. This law also created some limitations on what a landlord may consider when deciding whether to rent to an applicant. So first, they may not consider any rental or credit history that is older than 7 years. If someone was evicted 8 years ago, that shouldn't be asked about. That shouldn't be considered. They may also not consider certain types of criminal history. And specifically, they cannot consider any arrest that do not result in a conviction, or can they consider any convictions that are older than 5 years? Now, there are 4 exceptions to this. So specifically for convictions that are related to homicide and murder, manslaughter, convictions that are related to stalking, the selling or manufacturing of methamphetamine, or crimes that would require someone to register as a sex offender. Those convictions can be considered regardless of how old they are. But for all other types of convictions, if they're older than 5 years, they should not be a factor in deciding whether a landlord chooses to rent to that person. Next slide, please. Finally, I would like to address renters' rights regarding security deposits, which are often required by landlords at the start of any rental agreement to cover any possible damages that might occur to the unit. First, please note that the law says that a landlord may only retain a security deposit to cover unusual damages. It may not be used to cover normal wear and tear that's caused by someone simply living in a unit in the typical way. If a landlord keeps part or all of the security deposit, they must provide a renter with a written statement that describes exactly what damages were caused that required the deposit to be used. The law generally requires that a landlord return a person's security deposit within 30 days, though this can be longer if the lease allows it. In no case, however, if a landlord keeps part of the deposit, may they take longer than 60 days to refund any remaining amount. So the default is 30 days, but it can be as much as 60 days if the lease allows for it. It may never be any longer than 60 days. Next slide, please. All right. I know that was a lot of information. I will say that in closing, this was a challenging legislative session on housing, but also one that offered the promise of significant progress. And I feel optimistic that the fruits of this 2021 legislative session will bring some much needed relief to Coloradans who are struggling. Nonetheless, we will all have to work together to make sure that these new protections are implemented and enforced appropriately. We're all in this together, and we here at the Property Law Project are here to help however we can. With that, I know we're getting close to 7 o'clock, so I want to stop here and hopefully answer any remaining questions that you might have. Thank you.
I have a question. I always have a question, but my question is to clarify getting that deposit return. What if there is a unpaid portion of your rent, and there was a mutual rescission of your lease? Does that landlord that landlord get to keep that remaining amount, or do you still get to keep that if there were no damages?
I know that landlords will try to, and my understanding is that the law does allow them, but I want to confirm that with 100% certainty in case there's any case law on that question that I've missed. In fact, if any of my colleagues here on this call know otherwise, please feel free to chime in. But my understanding is that landlords often do and can recoup past rent payments from security deposits.
Actually, I think Lauren might be able to chime in on that.
I was gonna say, I'm pretty sure I think that is a true statement.
Yeah, that's my understanding as well. The landlord can retain any amount of your security deposit to cover your unpaid rent.
Yeah, and the reason for my question behind that was make sure that was clarified from the slide.
I'd like to really turn to the chat and answer some of the questions in the chat. So thank you, Aryadas. We very much appreciate you. But at this point, there are some other people on this call that have some questions. So Lauren, would you like to field a little bit of those that are in the chat? Sure. Looks like Garana has some questions. One I see is that if there are multiple renters being evicted, does the plaintiff need to serve a summons for each defendant?
I really like that question.
My understanding is that there's a requirement that a summons be issued per household facing eviction. And so if everyone's residing in the same household, I believe it can be a single summons, but please correct me if I'm wrong, my brilliant coworkers.
I agree, Jack, because usually the complaints say, you know, and all other occupants. So I think you're right. And then go ahead, Jack.
If it's the same building, but different units within the building, different households, then of course that would require an individual summons.
Right. And then another question along those lines, is a summons subject to attack because it doesn't contain the answer in the language that 173 requires?
That's a good question. I don't know, given that this law has just become effective less than 2 weeks ago, I doubt there have been any legal challenges questioning the legitimacy of a summons in the last 13 days. But I would be very interested in that possibility if a summons is insufficient, if it's lacking the requisite information that's needed to inform the tenant of their obligations. I do think it could be something that could be challenged in court under an argument that it was insufficient notice. But I don't know if there has been much in the way of cases to test this recently.
Another attendee asked if we provide assistance in Spanish and if we can help people without documents.
Yes and yes. Please do reach out to us. If Spanish is your preferred language, we will make sure to be able to communicate in Spanish, and we do not inquire about immigration status.
Awesome. And I see Nadine has their hand raised. Would you want to come off mute and ask your question?
Sure. Sorry. So thank you for that presentation. That was really helpful. 2 questions, if I may. I know you referenced the warranty of habitability. Is there going to be a subsequent session that dives more into the warranty of habitability? And then secondly, in talking about, I forgot on the slide what was the regulation that was referenced, but it was about housing access to all. Said that folks for state-funded programs would be able to access regardless of immigration status. And I was wondering if that also was open to people that might have felonies in their criminal background. Would they be qualified to be able to participate?
Those are 2 great questions. Thank you so much for asking. Regarding your first question, I know that there is ongoing interest in improving Colorado's warranty of habitability and raising the standard for what is expected in terms of safe and healthy housing. The last big update occurred in 2019, and we're still trying to work through some of those changes, but we already realize it's not enough. We hear stories all too often about people who have to go without basic essentials. And so there's, I think, widespread recognition that there is still much more room for improvements in terms of bolstering Colorado's warranty of habitability. I don't know if we're going to see much in the way of legislation introduced on that in 2022. I hope we do, and if not, I hope that it comes soon thereafter in the coming years. But I will mention that there's also interest in addressing some of these issues on the more local level. So, for example, in the last few months, Denver City Council has passed an ordinance that requires periodic inspections of most units operated by landlords. That can also be a method for addressing safe and healthy housing. So this is all to say that there is more work to be done. And we look forward at the Poverty Law Project to working with many of you on some of those efforts. Regarding your second question, no, unfortunately, the law that I mentioned that passed, House Bill 1054, all that did is it ensured that these state-funded housing programs are available regardless of immigration status. It didn't necessarily protect people that might have a felony record. Now, the law that I mentioned, the Rental Application Fairness Act, does place limits on what a private landlord can consider in terms of felonies. Again, they can't consider most felony convictions that are older than 5 years, with those 4 exceptions. But it doesn't apply necessarily to nonprofits or governmental assistance providers. So if there's a program that provides a voucher, for example, they can still take into consideration felonies, and unfortunately that can be the basis for denying someone a voucher or denying them other types of financial assistance. So I think your question has really highlighted a shortcoming in our public policies that personally I think warrants more advocacy and intervention, but I appreciate the question.
Thank you so much. It looks like we are at time. So if anyone has any follow-up questions, please feel free to contact us at Colorado Poverty Law Project. Thank you so much, Jack, for that wonderful presentation and all your involvement in the legislation that got us to where we are today. We appreciate you, and thank you all for joining, and we hope you have a great night. Thanks again to the Language Collaborative for providing our interpretation so everyone can hear our presentation in the language that they call home. Have a great night, all.
Thank you, everyone.
Thank you, everybody, for coming.
Thanks, everybody, for coming. I'm still printing at the print shop. That's kind of why we're doing the live stream of Zoom, because usually I don't have any time for those. Definitely think this is some important information. People need to know that there are housing rights for renters, that evictions can't just happen where a landlord shows up on day 5 and says, that's it, you're out. I've changed the locks, and you'll find your stuff on the sidewalk. So we want to thank all of you who came in to join in. Robert, Jonna, Carol, Into, Amazing Audits, DJ K. Happy Hippie, All Around the Pigs. Everybody else, thanks for joining us. Have a wonderful night, and we'll catch you soon. Don't forget, if you need printed apparel, contact me. cuttheclassic@gmail.com, because we're running a sweatshop into the middle of the night. Have a good one.